Appeals of Tennessee is now in session.
Good morning and welcome to the Tennessee Court of Appeals. First of all, I want to share with both of you that we appreciate you agreeing to participate with us via Zoom. We believe it's the best way for us to continue to transact the business of the courts at this time. Before we get started, I want to introduce your panel for this morning. You have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Even though we are participating in or conducting this oral argument via Zoom, all the same rules and procedures will apply as if we were all in the courtroom together, which means each side gets 15 minutes to make its oral argument, and the appellate will receive whatever rebuttal time it is reserved with Mr. Hibner before court. We do not anticipate any technological glitches here. If any do occur, everybody just remain calm. We'll get them fixed, and we'll make sure that any problem does not prejudice either of the parties in any way. Mr. Hebner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
Erroll Sherrod versus Smith & Nephew, Inc.
And we will hear from the appellant.
Good morning, Your Honors. May it please the court, Jasper Ward from Louisville, Kentucky. On behalf of the appellant, Mr. Sherrod, I've asked for 3 minutes of rebuttal time.
You may proceed.
Thank you, Your Honor. I apologize.
No problem. No problem.
The trial court's grant of summary judgment to Smith & Nephew should be overturned for 3 separate reasons, each of which on their own would be sufficient. First of all, the device that harmed Mr. Sherrod, a Smith & Nephew metal-on-metal hip implant, was not approved by the FDA under any process, and in fact, was denied approval 3 times. So the device that was put into Mr. Sherrod does not enjoy any sort of preemption protection for claims arising from its failure and its defective nature under the Tennessee Products Liability Act.
Mr. Ward, let me ask you, is a letter denying approval, is that part of the record, and does that letter set out the reasons for denial?
I believe that the letter is part of the record. I cannot cite to it at this moment. It's in the complaint, described in the complaint. It is described in at least the expert report of Mr. Pellerite and Ms. Truman, who are experts in this case, and the specifics of the reason for denial are generally discussed throughout the complaint in depositions and generally in the record. I cannot at this time, and I can try to follow up afterwards if the court would like with a specific record site for those letters. The individual components that make up this device were approved by the FDA for different uses in different devices. The metal-on-metal hip implant that was put into Mr. Sherrod consists of a cup, which goes inside the hip bone. So the ball and socket that we all, anatomy for lawyers understand as part of the hip. The socket or the cup was approved by the FDA for use with a different ball or femoral head. So that surgery is a different surgery that takes different parts of the patient's anatomy and uses a metal device on top of it. The device that was put into Mr. Sherrod included the cup from that PMA approved device and a metal head, stem, and a piece that ties the stem and head together called a taper junction. Those components were approved for different surgeries. Specifically, the metal head was only approved by the FDA to be used against a patient's bone. So no metal cup on the other side. The combination of all those things is what Smith & Nephew sought approval for. That approval was denied. Therefore, even if one component enjoys preemption protection for claims related to that component for use according to its approval, that does not apply to the device as a whole or to defective claims for defective condition or product liability for the other components that were used in this. in Mr. Sherrod. The case law involving preemption and mix and match or off label or even used according to label is complicated. There's cases all over the country, but the key part of those cases is another reason why the trial court should be overturned here. Even in cases where there is preemption protection for design defect claims, other state law claims survive if those claims are parallel to the federal requirements for the device. So in this case, misrepresentation, negligent misrepresentation, and other claims that were not subsumed by the Tennessee Products Liability Act, those claims can survive even in a preempted device situation. And in fact, in the case law that the trial court relied upon, those claims did survive. It was error for the trial court to dismiss all claims related to this device, even under the cases that the court cited, and even under the court's decision that the only thing that matters was the PMA approval status of the cup, which is again only one component in this device. So even under the court's flawed determination that the device at issue is just the cup and not the other components, there are still claims that survive against that cup involving misrepresentation, negligent misrepresentation, and there is sufficient evidence in the record from Mr. Sherrod that those claims were sufficient for a jury to determine whether Smith and Nephew violated Tennessee law as it relates to representations, misrepresentations for those components.
Let me ask you, Mr. Ward, and I know from your brief that you engaged in extensive discovery before having a hearing on the motion of summary judgment. Is there any proof in the record regarding any marketing by Smith and Nephew that your client's doctor would have been aware of that influenced him to use these off-label components together?
Yes, Your Honor. We would point to the expert reports of Mr. Pellerite and Ms. Truman, who discussed the sticker system, for instance. There are color-coded stickers that tell the surgeon this head goes with this cup, which the FDA did not approve that head with that cup. So the use of stickers to make those two components match is an example of it. The surgeons were brought the device by the sales representatives, and the sales representatives bringing the device to the surgeon is part of that promotion.
Yeah, I understand all of that, and that's probably great for that multi-district litigation. But in regard to this case involving Dr. Nadad, I believe is his name, what is the proof in the record that he had certain promotional information from Smith and Nephew that led him to believe that he could use these components together? Because I think you will agree, if he decided to do that on his own without it being promoted by Smith and Nephew, you wouldn't have a claim against Smith and Nephew for that use.
So
Do you agree?
I don't agree. I think that if he decided to use this device on his own, well, let me back up. The evidence in the record is that he knew about the device from Smith and Nephew, from his training, from his use. He believed it was approved through his use of the device and through his use of and conversations with Smith and Nephew sales representatives, training on the BHR device involved discussion of this THA device. So there's no way he could have known it existed on his own. He didn't just come up with this combination to use together. But even if he did, even if he just decided one day, I know that this head is out there, I know this cup is out there, I'm going to put them together. What Harold Pellerite, the expert, says is that as an unapproved device that was denied approval by the FDA, that the sales rep and the Smith and Nephew at that point have duties to inform him of that denial. He can hand them, once the sales rep has to bring him those components. So bringing those components together and providing the device without telling him, the FDA denied this device to be used together. So I know you think, under the court's hypothetical, the sales rep is then supposed to say, that sounds like a great idea to use these together, but I need to let you know, the FDA said this device itself combined is not safe and is dangerous. That failure is its own separate claim that is parallel to federal requirements, as set out in our briefing, for Smith & Nephew that apply not just to the BHR cup, but to all devices in general. So I hope that answered your question in terms of the facts of this case. The surgeon could not have just on his own come up with this device and thought of it, because that's not how, in practice, this surgeon or any other surgeon that's part of these cases across the country has done it.
So in the deposition of Dr. Nadal, there will be testimony that he used these 4 components together because of promotions by Smith & Nephew, if I understand your argument.
So I think so. I think we don't have a mailer, we don't have a commercial, we don't have a marketing piece that would count as, them going out and selling this to him as a device in the marketing sales representative promotion sense that I believe the court's asking, but promotion means more than just marketing. So in his deposition, there is evidence that he believed this device was a device that was approved that he could use, and he did that because of Smith & Nephew's conduct. Those are our allegations. That's what our experts say. That's what he says in his deposition. The stickers were part of that. The stickers on the device itself, on the boxes, are part of that promotion. And so a company like Smith & Nephew knows that it's not supposed to send out a commercial to a surgeon saying, hey, you should use this device, even though it's been denied by the FDA. But when they have a sales rep bring the device to them, when they train the surgeon on the existence of this device for training in another surgery, those are the sorts of things that count as promotion according to our expert, our evidence, and our arguments. And those sorts of claims, even under the Schuker decision, even under Hafer, which is another decision cited by the trial court, those sorts of claims are not extinguished under the Tennessee Products Liability Act, or even for a preempted device that's used exactly according to how it's supposed to be used. And so I think the short answer to your question is yes. In his deposition at trial, there will be testimony that Smith & Nephew promoted this device to him. Yes, Your Honor.
All right.
So I guess the last thing I'll say, my time is about out, is that the overall device and each individual component should be looked at and have its own separate preemption analysis applied to it. The overall device was denied FDA approval and was not given pre-market approval. Therefore, there's no preemption for claims for defects from the device as a whole. The modular femoral head, which is only supposed to go against patient's bone, that design is defective. The warnings for that were insufficient, and claims arising from just that component survive. The same with the neck and the stem that are part of that modular femoral head. And all other claims are parallel state law claims that are not preempted, even under the cases cited by the trial court.
Right, thank you. We will hear from the appellee.
Good morning, Your Honors. Douglas Moore on behalf of Smith & Nephew, the defendant and appellee in this case. We are asking this court to affirm the decision of the district court in determining first that preemption under the express preemption provisions of the medical device amendments to the Food, Drug, and Cosmetic Act apply to the plaintiff's claims, and I use that word purposefully, apply to the plaintiff's claims, and that there is no theory that they have advanced under Tennessee law that would not impose a requirement on the PMA-approved device at issue in this case that would not be different than or in addition to a federal requirement governing the device. I want to start with addressing a couple of points, though, that were raised by Mr. Ward in response to Judge Armstrong's questions. The summary judgment process is not about testing the sufficiency of the allegations in the case. It is about testing the sufficiency of the evidence that the plaintiff has adduced and whether they can show that they have a viable legal claim to pursue and that that evidence has created a genuine issue of material fact. Their opposition to summary judgment is on page 248 of the record. They submitted 4 exhibits. The first is a list of cases that they filed in Maryland in their multi-district litigation. The second is 1 page of testimony from a gentleman named Wally. Actually, his name is Erroll, who's their regulatory expert. 1 page. 3 pages from a sales representative of Smith & Nephew who covered the region where the plaintiff lives, there in Knoxville. And the last was an unpublished decision from a district court in California. Your Honor, to answer your questions about whether or not there is evidence in the record of, I think the first question you asked was this letter of denial from the FDA as it relates to the modular femoral head. The answer to that question is no, it's not in the record. It was not among the 4 exhibits they submitted in opposition to summary judgment. They didn't submit in opposition to summary judgment any of their expert reports. They block quoted 1 quote from the implanting surgeon in their opposition. But when I looked in the record, I couldn't find the actual transcript as an exhibit to their opposition. And so had they attached those regulatory communications from FDA and the company when they were seeking approval for the modular femoral head to be used in a total hip arthroplasty, the word that you would not see in that letter is denied. It's not there. What FDA did was they said they could not approve the application this time and asked for further information from the company. And then they withdrew the applications to the new, and there's a whole regulatory story there, not in the record and not relevant to the determination of the legal issues that are before the court. To answer the other question, will there be testimony from Dr. Nadad that he was promoted into using this device in an off-label manner? I know Mr. Ward has a lot of cases. He's gathered a bunch of these cases and he's sat through a bunch of these depositions. And so I'm going to forgive him for not knowing the specific deposition testimony in this case, but there is no testimony from Dr. Nadal, and certainly none that's been submitted in this record, that he was promoted by Smith & Nephew to use this product in an off-label manner. His law partner, Mr. Davis, asked, how did you learn about the combination of constructs? He says he doesn't know. He doesn't remember. He usually learns this information from colleagues, other surgeons who are using products and having success with them. He could point to no statement from Smith & Nephew that the product that would constitute off-label promotion or that induced him to use this product in an unapproved manner. That said, off-label use is an endorsed and accepted medical practice by FDA. FDA does not regulate the practice of medicine. Judge Wagner cited specific provisions from FDA and from other cases involving off-label use of medical products as to its significance. FDA approval governs how a medical device manufacturer can market a device. If it goes through PMA approval, it is given an indication, and that is the indication by which the company can market the device. If it is obtained through a 510K clearance, which is a different regulatory pathway, that means that the product is substantially equivalent to an existing device that's on the market, and they can market it for those indications. But FDA approval and FDA 510K clearance does not govern how a medical doctor can decide to use a medical product. They can use whatever construct they deem to be appropriate for the patient based on their medical judgment, regardless of whether they are approved or not. And that is precisely what happened in this case.
Well,
So
let me ask you, Mr. Moore, if a doctor uses devices in an off-label manner and it turns out that it's not safe, would there be a viable claim against the manufacturer if they didn't promote this off-label use?
If they did not promote the off-label use, I don't think there is any court in the country that would permit a claim for a PMA-approved product to proceed under that hypothetical. If we looked at the Schuker decision, which was from the Third Circuit Court of Appeal, which was a case against Smith and Nephew. It was the question is whether preemption applied in that case to a construct that was essentially the same. There was a point made in the brief, well, oh, this was a different product. It was a two-piece BHR cup instead of a one-piece BHR cup. They were approved under the very same PMA application. So it wasn't even a different application that the court was considering in the Shuker case. And what the Shuker court determined was that PMA preemption applied to the device, and it dismissed claims in that case under Pennsylvania law that would have required a finding that the device was defective or unreasonably dangerous, or that would impose a requirement that was different than a federal requirement for governing the device. But what the Shuker court did not dismiss were allegations in that case, and they were just allegations because the Shuker court was a 12C motion. We didn't get to the point of testing whether they had evidence to prove their allegations. But the allegation was made in that case, well, the doctor used it as a consequence of illegal off-label promotion. And that was the claim that the Shuker court preserved. And under your hypothetical, if there were not off-label promotion, then there would be no claim to be pursued under those facts, Your Honor.
All right, but under the facts in our case, you have a class 3 approved device, and then you have 3 other devices that are only class 2, so they don't have the pre-market approval. If you use those other 3 devices in an off-label manner, it's not, you're looking at the labeling required by the FDA or FDCA, and the doctor uses them differently, how does that affect preemption?
So under the facts of this case, and I think the courts that have looked at this have analyzed whether or not preemption applies to the plaintiff's claims. And the distinction I think that is sought to being made, and the point that I think Your Honor is focusing in on, is whether preemption might not apply to some parts or pieces of the construct that the plaintiff received in this case. But the question is whether or not they can impose liability against Smith and Nephew without imposing a different requirement on the PMA approved component. So I think the focus should be less on which part or piece has what approvals and whether they can prove their claims without implicating the BHR PMA approved component. And to explain that, I brought some parts and I showed these to the district court, just so the court understands. This is a BHR cup. It's just a metal cup. This goes in the pelvis of the plaintiff. This is the BHR resurfacing head. So when you have a resurfacing procedure, they put this on the end of your femur, and this articulates, and that's your new hip joint. The cartilage is gone, and now you have a different material, and it's metal. And when you're walking around, this ball articulates against the head. The argument for this is, and they've filed cases on this as well, that metal debris from the ball and the cup articulating against one another creates an adverse reaction in the body and requires the components to be removed earlier than they would have liked. In Mr. Sherrod's case, he got the PMA approved component, the BHR component, but he got a different metal head, something called a modular femoral head and a total hip arthroplasty. And this stem goes down in the femur, and it's the same exact dimensions of the metal ball that I just showed you, and that articulates against the cup in a different, construct, a THA construct. But the allegation, the mechanism that causes the injury, is the interface between the PMA approved component and the 510K cleared components. This by itself, if this were used in something called a hemiarthroplasty, where they just have it articulate against the naked acetabulum in your pelvis, this happens when you have like a fractured femur. They'll put this on the end of your femur, and it'll just articulate against your native tissue. That doesn't cause metallosis. That doesn't cause adverse tissue reactions. This by itself doesn't do anything. It's only when you pair it with the PMA approved component that it produces the injuries that are at issue in this case. And so that's the point that Judge Wagner accepted. It's also the outcome, the plaintiff's focus on Judge Blake's Rule 12 decision in the BHR MDL. There's 2 tracks, one for the resurfacing device and one for the total hip device. And there was a Rule 12 motion filed there. It was in response to a master complaint. So it didn't apply to any individual's facts or any individual state law. And what Judge Blake determined, the path that she resulted was a little bit different than what the Third Circuit had decided in the Shooker case, which was also addressing these devices and whether preemption applied. But what Judge Blake concluded was that strict liability claims that require finding of unreasonably dangerous or defective, are preempted even for this construct. That is what Judge Blake and the MDL determined. And what Judge Wagner asked the plaintiffs during the oral argument is, look, the decision you're pointing me to, instead of the Shooker decision, Judge Blake's decision from the MDL, she concluded that claims that require a finding of unreasonably dangerous and defective, those are preempted. And in Tennessee, under the Tennessee Products Liability Act, all of the theories of liability require a finding of unreasonably dangerous or defective. And so how is there a parallel claim in the state of Tennessee that can survive if the BHR cup is at the heart of the plaintiff's claims? And that's what Judge Blake determines in footnote 8 of her decision, when she concluded that even the claims that I'm letting go forward at Rule 12 at the summary judgment stage, if the cup is at the heart of the claim, then preemption would still be appropriate. And that's precisely what happened in this case. We have a claim that cannot be separated mechanically from the BHR component. We have a products liability system in the state of Tennessee that requires a finding of unreasonably dangerous or defective. That conclusion necessarily imposes a requirement that is different than what the federal government determined when it concluded that this product was safe and effective. And as the cases cited by the district court, the Hager decision in particular determines that off-label use of a PMA-approved component does not change or strip it from its PMA preemption protection under the Supremacy Clause of the US Constitution. Now, in my last 2 minutes here, I do want to address a point that was raised in the papers, and that is, and Mr. Ward brought it up during his comments, and that is that claims of misrepresentation or warranty, there is jurisprudence, notwithstanding what the TPLA says. The TPLA says no matter what the theory, there has to be a finding of unreasonably dangerous or defective. There's jurisprudence that says that misrepresentation claims or warranty claims, express warranty claims, are not governed by that requirement. So the question then becomes, well, are those claims nonetheless preempted based on the theory that would be advanced to prevail upon them? And if you look at the complaint and the opposition to summary judgment, there is no basis to conclude that there is a triable issue of fact or a viable misrepresentation claim based on what they articulated in the complaint based on the lack of evidence submitted in opposition to summary judgment. The court also addressed the question of implied preemption because many of the allegations that are made throughout the complaint address enforcement of the Food, Drug, and Cosmetic Act, which a state court litigant doesn't have the ability to do. Only the FDA can do that. And so I appreciate the court's attention. I know that I've been talking kind of fast and throwing a lot at you. It is very dense material, but we believe the district court correctly determined that preemption applies to this device and that there has not been stated legally or with sufficient evidence a viable parallel claim in this case based on the summary judgment record. For that reason, we ask the court affirm.
Well, let me ask you, Mr. Moore, in Judge Wagner's opinion, does she specifically deal with the plaintiff's claim regarding the negligent misrepresentation or marketing these 4 devices, only one of which had been a pre-market approved, being used together? And then we know from what's occurred here and in other cases that the use of these devices together leads to this, I think it's called metallosis. Did the judge Wagner specifically address that claim in her opinion?
I believe that she addressed it. I don't know if she addressed it as specifically in the terms that the court is describing, but she went through each and every count articulated by the plaintiff and analyzed whether or not those counts would impose requirements on the PMA approved component. There are allegations in the complaint about off-label promotion. There is no evidence in this record of off-label promotion as it relates to this doctor. The 3 pages of testimony from the sales rep that they referred to about this color coding, what the sales rep testified to is that when you have a modular femoral head, there's a trial head, and they're color coded to go together. That has nothing to do with promotion of the device. The device is already in the operating room by the time that those color codes even come forward. And the testimony from the sales rep is that the purpose of that color coding is not for the purpose that they say it is. But still, there's no evidence in this record that this doctor was induced to use this product as a result of any promotional activity from the company. But putting aside the lack of evidence, if you look at the misrepresentation claim in the complaint, all they say is, we adopt all of our allegations above, and you didn't tell the world that this product wasn't safe and that it was defective, and that's a misrepresentation. Well, we're not required to tell them that it's not safe or defective because that would impose a requirement on the cup that doesn't exist, and that would also make it preemptive.
Okay.
All right, thank you. We will hear from the appellant in rebuttal.
Thank you, Your Honor. The summary judgment, sorry, I'll wait for the clock to start. Sorry, the summary judgment briefing and the summary judgment order was about one narrow issue, which is why the record on summary judgment is different than the record on appeal, which is different than all of the evidence that we've acquired in this case and other cases that would be relevant evidence at trial. So the summary judgment issue and the summary judgment order was one very narrow issue. Is the device as a whole under the TPLA, are all claims extinguished because of the TPLA and because of preemption and because of the pre-market approval status of one component? That was what the summary judgment was about. That's what the briefing was about. The record on appeal includes additional evidence that shows why that decision was erroneous. The plaintiff's expert disclosures are at 175 on the record on appeal. Mari Truman, who's an expert, her report is specifically at, I believe, and I apologize, I had it up on my list, but her report is in the Court of Appeals record. And so that evidence is in the record. The summary judgment order was wrong because the BHR cup and whether or not is defective is not the heart of Mr. Sherrod's case. The heart of Mr. Sherrod's case is the entire device, the stem, the thing that holds the stem and the head, the cup, that entire device is effective. And so the court in Baltimore ruled claims arising from whether that entire device are effective or defective or not are not preempted. If it turns out that the design of the BHR cup is the heart of the case, then you may have a problem on a design defect claim. But under Schuker and other cases, you still have other claims, you still have parallel claims, and those sorts of things, the evidence for those, we believe is in the Court of Appeals record, we believe it's in the briefing and in the complaint, and there is sufficient evidence of that if the court were to overturn and send us back to the trial court for a further analysis of whether the stickers, for instance, I believe that's a factual dispute as to whether the stickers constitute off-label promotion or not. But that wasn't part of the dispute. That wasn't part of the court's ruling. There's nothing in the summary judgment brief or the summary judgment order that addresses that or not. And so it's I guess to get back to where Mr. Moore ended, the trial court's opinion does not provide a sufficient rationale to dismiss all claims related to all components or the device as a whole, because the court is simply wrong that the BHR cup is the heart of our claims and that the PMA status of the BHR cup overwhelms and undoes everything else about the device at issue. Thank you very much for your time, and I'm happy to answer any questions.
Mr. Ward, tell me exactly, what is your parallel claim?
So the parallel claims for the BHR cup involve, so that I guess the question is, there would only be parallel claims if a device has PMA status. The only device at issue here is the BHR cup. So the parallel claims involving the BHR cup would be negligent misrepresentation and warranty claims regarding representations that Smith and Nephew made about the BHR cup itself. Those claims are in the complaint. Those claims are throughout the MDL evidence that the parties have agreed. We don't need to recreate in each case and don't need to redo discovery in each case. So the only parallel claim analysis that the trial court should have done would have been for the PMA device itself, which was just the cup. The parallel claims for the rest of the device and for the non-PMA approved components would all be related to, I mean, basically the federal requirements that you're not to sell this device, right? So the device was not approved and the letters of approval say you may not market this device. So our expert, Mr. Pellerite, talks about marketing an unapproved device violates federal requirements. So even if any preemption applied to the device as a whole, the marketing and the off-label promotion that we have advanced evidence of would be parallel claims because that would also violate federal requirements. The only medical, the whole idea of medical use and the ability of a surgeon to use a device, the medical use exception is for a legally marketed device. So a surgeon using a device off-label, the device has to be legally marketed in the first place. The entire device, the total hip, stem and head and taper and cup in combination is not a legally marketed device. And so therefore there's no exception or there's no medical decision exemption for the use of that whole device because it was not legally marketed.
All right, thank you. We will take this matter under advisement and endeavor to get you an opinion as soon as possible. We appreciate you participating with us via Zoom. Mr. Hibner, anything we need to take up before we recess the court to the call of the next case?
No, Your Honor.
This court.
Thank you, Your Honor.
This honorable court is now in recess until 1 p.m.